It's about 2 after, so we're going to go ahead and get started, but I got a little housekeeping that I want to do first. This is a CLE webinar, which means that in order to get CLE credit, you've got to stay here for the full hour. You get a 1 hour CLE credit, which we'll be getting out to people shortly after the webinar. We also are recording it, so we'll be able to get the recording out to those people that want it. The other thing is there is a Q&A. If you go down to the bottom of your screen, you'll see a little question mark that says Q&A. If you have questions for Taylor, you can put them in there. And at the end, hopefully we have time to answer some questions. And with that, I'm going to go ahead and give a brief intro for Taylor, and then I'm going to let him take it away. By the way, my name's John Blake. I'm the VP of Revenue here at Anytime AI for those I haven't met. Appreciate you showing up today, and hopefully this helps out your practice. So Taylor is the 2024 California Lawyer Attorney of the Year. He got a $63 million verdict and is on the California peer-chosen top 40 under 40 list. He won the Daily Journal's Verdict of the Year and has repeatedly turned not real TBI cases into 8-figure results. He spent 5 years writing the definitive book on TBI litigation, which is dropping this summer. Every week, 5 to 7 attorneys he's never met reach out cold asking for help on their toughest TBI cases. He helps them, no charge, no ego, just results. And that's one of the things I actually like most about him is he's willing to share his what can help other attorneys with their TBI cases and doesn't look for anything from it. While most lawyers keep their strategies close, Taylor believes both the lawyer and the client deserve better. He knows he can't take every case, but he's seen firsthand how sharing what works can raise the bar for everyone. And that's why after years in the trenches and some of the biggest verdicts and settlements in California, he's here today to pass on what's proven and to help every lawyer deliver the results their clients deserve. And I really appreciate you myself for coming on here and doing this with these folks. So with that, I'm going to let you take it away.
Yeah. Hey, thanks, John. So
Yep.
more than anything, I just want to say thanks for you guys for coming. The whole goal here is today is you got to spend an hour. The most precious resources that lawyers have is time. And so if you're going to spend an hour with me, I'm going to try and give you something you're going to be able to A, use immediately, and B, significantly increase the value of one of your cases by such an amount that you're like, wow, that was worth listening to. That was worth doing. And it's one of the things that I consistently talk to other lawyers about is a lot of lawyers are like, I want the firm to refer the case to me. Like, I don't need that. We're firms in a situation where we just want to help other lawyers and help them do their TBI cases better. There's so many in the US. There's enough work out there. And what I want to show you today is some of the frameworks we use about how we use and leverage AI to solve some of the biggest issues that our firm has to basically get the better results, settlement, verdicts, however you want to look at it. And we'll take some questions at the end. Basically, gloves are off. You want something from me, ask, and I'll see what I can do to get it to you. So that's kind of it. So I've got a little bit of PowerPoint presentation stuff that I can kind of go through because you need to see some of the pictures. And with that, we're going to kind of show some of this and get going. So about where I came from, let's see if we can screen share this. Here we go. Oh yeah, we got this cool logo thing. This is
Ooh, ah.
I know. It's cool. It's like the people tell me like, hey, you've got to play that, but it's whatever. So, I grew up, my grandpa was a farmer in Paso Robles, California. It became like a wine area, but basically I had this whole bent growing up where farmers have this deal that my grandpa farmed with all his uncles and, brothers, and he basically did this thing where you do a handshake deal. They operated a farm for most of their lives and they didn't have anything ever written down on paper about how they're splitting up anything. And we kind of like to take that same approach to law is you take that whole farmer approach and you apply it to lawyers who always want everything written in deals and this and that, but it's the spirit of it. Like, hey, if you were going to act as somebody 100 years ago that did handshake deals, what would you do? And I think it's really made an impact on how we see cases. For me personally, I grew up kind of with a chip on my shoulder. Um, I I'm just be tell you something pretty vulnerable for a second. I had a bunch of skin issues when I was a kid. I had something called eczema. I fundamentally felt like there was something wrong with me, and the only way to overcome it was wildly achieving everything. And so anytime there was anything that school, multiplication tests, college, law school, being a lawyer, being a trial lawyer, all of it was I had to do everything better and cleaner than everybody else. And it was just kind of part of my identity. And how I got involved in TBI cases kind of happened when I was younger. I had a friend of mine, he was 13, I was 13. We went over to a neighbor's pool and he jumped in. It was the deep end, but the deep end was only 6 feet deep. And he hit his head at the bottom and I had to pull him out of the pool. And he suffered a mild traumatic brain injury at 13, and he was never the same. I still know him and I'm still friends with him now, but he has um, a very significant different personality. He's got a lot of challenges for a lot of things. He did graduate from college, has jobs, does things, but it's his life is forever changed, and I basically got a front row seat to the whole thing. And it made me interested in TBI cases kind of since before I was even a lawyer. I didn't really understand the impact it was going to have on my life, but it's been pretty significant. So this isn't just, hey, TBI cases can be valuable cases. This is something that became personal to me pretty quickly. Um, yeah, I work hard because of fear. Basically, lawyers in depots, I've gotten laughed at. In trials, they've made fun of me. I felt lost. Uh, every emotion that you've had as a lawyer, I've had big depots the next day where I'm like, oh my God, how am I going to possibly do this? And it just led to me working on cases. Because when I was a young lawyer, I got a TBI case, and then here's pictures of the types of cases we've worked on. And you look, there's a pressure cooker exploding, helicopter crash. This is a wine tank that exploded and threw our guy through a brick wall. You get the idea. We worked on some pretty significant cases. But before I talk about some of those, I want to talk about this singular concept that good cases are built, not found. And people go, what do you mean by that? And if you think you have a fabulous case, you have not done enough to make it even better. And I know that because of how many times I've worked on these TBI cases to do exactly that. So let me just show you a couple of things. Case study number one. I'm not going to use names, defendants, any of this stuff, but you guys can all see this picture. I want you to think, what is the biggest possible value you could get? This was the impact. You can see it's 11 inches. That's it. That's all the picture of damage to the car. This is the car that hit her. What's the maximum value? And the reason I do this is because this case settled for $1.6 million. And people are like, wait, what? Here's another case study. This is the car that hit him. This is the back of the car. What's the maximum value? It settled for 1.25. And the reason I talk about this is I love the movie Moneyball, and this is just I just I identify with this so much, which is
There
this. I want to make
is
sure you can hear the
an
sound.
epidemic failure within the game to understand what is really happening. And this leads people who run Major League Baseball teams to misjudge their players and mismanage their teams.
So this is a YouTube clip from Moneyball, but basically I think the same thing about TBI cases. I think there is a fundamental misunderstanding of like what drives TBI case value because so much of people judge TBI cases based off the diagnosis in the initial intake or the hospital or if there is a brain bleed. And the reason for this is what they put in the demand letters. Let's see if I can draw a little bit on this. What they put in the demand letters is here. This is the amount of information that we have if you just look at medical records. And what you need, and even working with these AI models, what you really need is you need the type of information that you're going to present at trial, which is widely larger. And the reason for this is something that it became kind of the backbone of the book in TBI litigation that it's coming out later. You'll read about it if it's something you're interested in. But most people, when they look at a case, they look at the initial intake medical record, they talk to their client, they look at some additional medical records, and maybe they talk to an expert. These dots represent the type of information that you get, but you don't have very much. And what you want to do is you want to rapidly gather significantly more evidence to choose from so that you can then present it to the jury or the defense adjuster, the defense lawyer, as, hey, let me tell you in the demand, this is all that you show. You show this, you show this, and you show this. And then you take away everything else. So when the defense lawyer, defense adjuster, or the jury sees your TBI case, all they're seeing is, I call these levels of evidence. The closer you get to the center, the less likely it is to be disputed. I'll give you an example of that. One of the most common defenses, I'll just stop this share for a second. One of the most common defenses you see in any TBI case is the defense in some way will insinuate or come out directly and say, well, your client's in it for the money. And if you know the defense is going to say your client is in it for the money, what you really are doing is you are trying to find a story or a core truth that fundamentally breaks what's happening. And so what you really need to do is look for a way to show the client isn't really in it for the money, because they absolutely cannot be in it for the money. So a story that we tell, and this is something internally we call story breaking, is you tell a story either through your client or through someone that knows your client that fundamentally discounts any belief that ever would possibly happen. So you know the defense is going to say, hey, the client's in it for the money. They're asking for tens of millions of dollars. You have a witness show up and says something along the lines of, hey, yeah, I knew the witness before the car accident or construction site accident, or they were hitting a crosswalk or whatever the injury was. Yeah, I knew her. And I was the person that told her she needed more spousal support from her ex-husband. What'd she say? Well, she said she didn't want spousal support and she was never going to apply for it. Why? Because she's somebody that always said, I'm always going to do it myself. I never want to ask for any help from anybody else. And my ex-husband, I just don't want to ask him for that. I'm not filing for spousal support. And so then you ask the follow-up. So you got divorced and didn't ask for any money for spousal support? Yeah, that's right. And you as her friend told her she should do that? Yeah. And what'd she say? I don't need any help. And what about this case where she's got a brain injury? This is the first time in my life of friendship of 27 years I've ever seen her ask for help. You tell a story like that, and the defense all of a sudden shuts up about, oh, they're in it for the money, because they know fundamentally they are saying something that's not true. And so going back to, I gotta click this. Going back to this, that would be what I would say a core truth is. Now, the problem with finding these core truths is they take a lot of effort and work to find. So lawyers spend all their time putting out all the fires on all the things that they're dealing with in their office. Some discoveries got some issue. There's a deadline coming up. They got to write a demand letter. They got to call a client back. Most lawyers spend enormous amount of time doing things that do not significantly increase the value of the case in any meaningful way. They do not find these facts because, frankly, they're not looking for them. They're spending their time working on other things that if they had better tools, they'd not be wasting their time on those things. So you want to leverage what is going to move the needle as much as possible throughout your whole firm over and over again. And if you are not saying what is going to move the needle in a way for the defense lawyer or defense adjuster, all right, let's just do a thought experiment here. Think of a lawyer that you know that you don't really like that much. Pretend that lawyer is representing your biggest client. Not because they're going to take them or anything, but just the thought experiment. And then that lawyer that you don't like wrote your demand. As an insurance adjuster, would you pay it? And that's the reason there's a fundamental disconnect of what the demands actually are, is because you need to write a demand where the cheapest option for the insurance adjuster and lawyer is, even if they don't like the person, even if they're like, oh, this plaintiff lawyer, they still look at it and go, it's going to be more expensive if we don't pay them now. They hold their nose and say, we got to get this done. That's the demand letter that actually moves the needle and goes, okay, that's actually really great. So circling back to the whole leverage concept is, we're spending time working on things that don't move the needle in our cases rather than finding these types of facts that as we talk about, you gather way more facts, you focus on the ones that matter, and then you reveal it to this is what the defense lawyer sees. So let's talk a little bit more about this because we showed some of these pictures here, and you look at it and you go, there's no way you're going to get 7 figures out of that. So let's talk a little bit about settlement values and what moves the needle. Because you go through gather, focus, reveal, you want to find this stuff. But lawyers, I get asked this all the time. I'm speaking on a stage or lawyers calling me saying, hey, can you look at this TBI case for me? Or what do I need to do? Or how's this work? And then they ask, well, how do you get that one case settled for $10 million? And I think this is the most common question I'm asked across all stages and lectures that I give. And the answer is this. You say no when they offer 9.5. And that sounds so simple to say. It is so hard to do because to get a case to settle for 10 million is they are going to offer you 5 and 6 and 7 and 8 and 9 and 9.5. And in 3 of those offers, they'll say, you're never going to get a better offer than this. $5 million. That's our last offer. You're never going to see a penny more. The mediator will tell you that. And how do you overcome it? And then let's do even a more extreme example. How about saying no to 23 to get a case settled for 25 or 30? Like, you have to be able to have enough conviction to reject the money to get the value of what the case is. Well, how do you do that? You do it by having the facts and gathered and put together the idea of what more than just the demand letter be, what the trial strategy will be in a way that you fundamentally believe to your core the case is worth more than that. And they're either going to pay you or you're going to try it. So let's do some more examples. And this example is one that you can see more serious injury. There's a bunch of broken bones, broke 6 or 7 ribs, broke his foot. He was in his late 40s. He was briefly unconscious, Glasgow coma scale of 15. For that you aren't aware of what a Glasgow coma scale is, it's a triage term about how well they were able to verbally communicate, use their eyes, and if they responded to pain. 15 out of 15 is the highest score. So basically, if you have a Glasgow coma scale of 15 and you're trying to do a TBI case, in trial, the defense says Glasgow coma scale normal as much as possible. So looking at this case, had some orthopedic injuries, but what I really wanted to focus on is I looked at it and I said, this isn't a traditional orthopedic case. And the adjuster called me really early, which I thought was weird. And she's like, we're never going to pay TBI value on this. It's an ortho case. That's it. GCS 15, not a real TBI. And I was like, there's no way he's in a collision like that and doesn't have a significant TBI. There's just no way. And then the adjuster was just giving me a hard time a bit. She's like, we heard he went back to work at Home Depot. So he's working hard part-time now too. So like, you have a TBI and you're working part-time, like that, this isn't a TBI case. We're never going to evaluate that. The firm that had the case before me was valuing it at mid-7 figures. I think they got an offer under $1 million, and they brought us in and said, hey, we want you to work on this. And this is something that I want to just show you an example of how AI can make absolutely all the difference about everything. And it really comes down to the fact that you need to gather the data in a way that you can quickly identify where the heart of it is. Now, I'm going to get on my soapbox to talk about anytime AI just briefly. I don't want this to be a super in-depth discussion about all the stuff that they're doing, but they keep your data private and they don't train on the stuff you give them, which is a big deal. Most AI companies, if you give them, hey, here's the checklist I need for trial or depot, they learn that checklist and they can roll it out to every other firm they're in contract with. Anytime AI doesn't do that. So if you give them, hey, here's the secret sauce, it's your secret sauce. It's never going to go anywhere. And that's different than every other AI company because all the AI companies are trying to make their models better where they don't. So this is one of the things from Anytime AI on that case. I redacted the patient's name because reasons. But more than anything, you can upload all the medical records, the first responders, the fires, the stuff, and you basically get a summary of all the doctors' names, where they went, and specifically all the stuff that is here. So you can see GCS 15. So yeah, he broke his leg and he had no significant neurological deficits. This is the kind of stuff that I know is super, super difficult to overcome when I want the defense and the defense lawyer to value it really significantly. They had loss of consciousness, but no significant neurological deficits. I know they're going to hit me with that. GCS 15, going to hit me with that. And, pre-diabetes, if you have MRI scans, that's a whole different talk that I will get into, but that makes it harder to get MRI scans. But the reason this is so great is after this comes out, if I want to go to one of these specific things, basically you click on this. I want to make sure this click works. And it goes directly to the exact setting of where it is. So you click on it, and frankly, I'm not sure that worked with me this morning. So let me see if I block something. You click on it, it goes directly to the medical record. And John, I'm sorry, it just worked. I don't know what
No
the
worries,
deal
it
is.
works. It's okay.
Yeah, you click on it and it immediately goes directly to the record, and you can read directly from the record of exactly what's happening. The reason this was so valuable is we were able to look at the medical records immediately, decide they're going to fight us on the GCS score and they're going to fight us on the neurological injury. So what do? You basically are not spending time reviewing medical records. You're spending time trying to solve the fundamental problem. Because when we got just the medical records, we were looking at this. Scroll. This is what you're looking at. You're only looking at a couple of data points. And so what we wanted to do with this case is we wanted it to look like this. So we called every witness at the scene. We talked to the firefighters. We talked to the ambulance people. We talked to anyone that at the scene, hey, did you see anybody else? Did you see anybody else that you knew there? And one person said, oh, hey, there was this off-duty firefighter that was at the scene that was working with him that he left. And we're like, off-duty firefighter, what's the deal there? We ended up calling around until we found the firefighting office who had the responder, tracked him down, got his phone number, called him. And this is the type of stuff that there's no shortcut for this. All the lawyers talk about, oh, we make the cases and it's the trial skill. I'm a trial lawyer and I'm telling you, the way you get great results at trial is by doing the hard work that people don't want to do. So we call this guy and we get him to say, yeah, he eventually came to and was doing some stuff and they put him in the ambulance to take him to the hospital. However, prior to that, I put him in precautionary procedures and I checked him for a Glasgow coma scale. I was like, well, what do you mean? He's like, oh, I'm off-duty firefighter. I know what to do. So I checked him for all the Glasgow coma scale stuff. And I think his Glasgow coma scale, based off my testing, was he didn't respond to pain. Which if you don't respond to pain, it is a neurological immediate reaction. Your Glasgow coma scale is 5 or 6. And I got that information and I figured out a declaration, and then we went and took his deposition in a way that we got it videotaped and in the can, that the defense experts for the rest of the case, pretty interesting what they did. They actually did this whole thing of, well, he's not an official firefighter and he wasn't trained properly as an EMT would be. And so again, we go back to him and we start talking to him more and found out before he was a firefighter, he was an EMT for 7 years. And so we took the defense expert deposition where she said he needs to be trained as a medical professional. Would EMT training count? Yeah. How many years would you need? Would, I don't know, more than 5 years qualify you as an EMT to do this type of training? Yes, it would. I'd like to show you the declaration. Can you look at this? Would this qualify to do the Glasgow coma scale? And all of a sudden, the defense lawyer is objecting and panicking and needs to take a break. And they're watching their entire theory of how to defend this quote unquote no TBI case explode. But the only reason we got that is we had more information than the defense did. And we had it early enough that by the time the expert depot started, we knew more than they did. And it creates this enormous informational warfare advantage where what we knew was this, what they knew was only in the medical records, and they made their opinions off just the medical records. And so you have that outside information that then you can use as a weapon that the defense lawyer, the expert doesn't want to look dumb. They just want to try and figure out what's the way that they can get out and not preserve their reputation. So when you start really pressing them on it, they have to give it up. So, we have fabulous tools to use as AI and basically setting up the foundation for stop spending time on the things that you think you need to spend time on because you've always done it that way. And I know this because this is what worked for me. I used to spend a ton of time working on the medical records and reading them all myself. You have to read all the medical records before you go to trial because you're going to find something in there that you aren't sure about. But being able to quickly have an understanding of where the fundamental nature of the medical records is going, or a summary of the medical records, or a deposition transcript that's summarized, it just is such a powerful tool. And the example that I end up giving to my friends that are lawyers and they're asking me about AI tools and all this stuff is, 200, 400 years ago, if you had to cut down a tree, you used saw. If you showed up, magical time machine, and somebody 400 years ago in Appalachia and got to cut down trees and make a log cabin, and you said, hey, here's this chainsaw, and they said, it's too complicated. With what we know about chainsaws now, you just be like, what are you talking about? Like, you got to prime it, you got to put gas in it, you got to get it started. But you are going to be able to build so much faster. You're not going to be spending time sawing the tree down. And that's kind of how I view AI. It is a tool that is until you are using it at the highest level, and there's always new features coming out. Like, they will train you. They literally will tell you how to do everything, what button to click, how to do it. And if you get lost, you call them because they're in the interest of trying to figure out how to make it easier for you so you stick with them for the long term. So yeah, cool graphic, I thought. The medical chronology of something made a fundamental difference on that case. And more than that, this ended up being an 8-figure case. Can't talk about it, confidential, blah, blah, blah. But, and they basically said we're never paying TBI value at all because GCS 15. But we didn't have enough facts. So we went and got facts. And then all of a sudden, magic happens. So let's look at some more case studies. Well, actually, before I get to that, what the medical record initially says in TBI cases is never the value of the case. I do not know how to make that more clear. Lawyers screw this up all the time, and because of it, they leave millions of dollars on the table. And I know this because when I was a young lawyer, this is how I thought. I'd look at the medical records and say, oh, it says subarachnoid hemorrhage in the parietal lobe, or oh, it says concussion without loss of consciousness. We know now that by the time they get to the hospital, it's been 30, 45 minutes. Of course, they're neurologically stable. 95% of TBIs are mild TBIs. Most of the time, they do resolve. But if they don't resolve, they're going to be something that's permanent for the long-term value of forever. So when you read the medical records, don't assume the diagnosis is the value. And if the diagnosis isn't the value, what is the value? And this is it, is diagnosis. If you just say diagnosis is the value of your TBI case, you're doing this. And basically you have this one red puzzle piece and you don't have what their friends and family say, what the people that knew them at work say, and how they interact with society in general. Like, you don't have any of these pieces because they're not in the medical records and we need to go get them. So here's another case study discussing about an 8-figure case. I'm going to go quicker because of time. But basically, the value of case is the value of the case goes up the closer not you are to trial, but the fact that the defense will know that you will go to trial if they don't pay you trial value. It's the reason that the two questions any defense lawyer asks when talking about a case are, how is the plaintiff? Like, how do they present? Like, are they credible or not? And then who's the plaintiff lawyer? Who's the plaintiff firm? And they want to know that because really what they're asking is, what is the likelihood that that firm goes to trial if you don't pay them? Like, that's what they're trying to ask. And if you give them a 80% offer, are they going to settle or not? If you give them an 80% offer and they settle, well, the risk of actually going to verdict, the defense firms all keep track of this. So I got lost here on this. Yeah. So next case study is another 8-figure case. Guy got electrocuted. And more than anything, is this one wasn't so much about the TBI that he got, which they said he didn't have a real TBI, and he walked away and he went back to work, and same thing. Went back to work, was working for a bit, worked for another couple months, and then stopped working and on and off. Didn't get burned from the electrocution. We were arguing it basically caused problem with his brain, and the defense was arguing that if it was going to cause problems with his brain, he would have been burned and would have had more long-term issues. This is how these Legos are how I view data until it's organized and sorted. This is what organized and sorted data looks like. So basically, when we have all our stuff written down in our office and it's just stuck in some lawyer's head about like, oh, hey, I'm ready for trial. And somebody's like, where's that depo? And where's this witness say that? And how are we going to prove the TBI about this specific symptom? That's what this data looks like. Yeah. You can't have data that looks like this and plan to put on a good case. You just can't. This is after you sort the data, and sort it means summaries, understanding what witness is going to testify about what deficit, what witness is going to do the liability. But more than anything is what you're really trying to do with Legos is build the car or build the house. And so it's much easier when you get everything sorted to figure out where blocks are that you want to pull it to build the house from. So we knew this whole electrocution thing was going to come down to a person most knowledgeable depo or person most qualified, depending on the state you're in. Basically, we were going to subpoena somebody at the defense company and say, hey, we want to get you for rules and regulations and policies and procedures and stuff. And we know, as one of the common defense tactics is the I don't know PMQ. They show up, they say somebody basically says, I don't know as much as possible, and they don't have any documents, and they don't know anything, and they deliberately pick this person. So if we know they're going to do that, think back to the blocks, and you're trying to build a house where there's strong liability stories you can get. What you do is you figure out, this is basically the concept of what AI can do for you if you do this right, or anytime AI basically builds a lot of structures to do this, is you take the raw data, you get it organized, you structure it to like what data is going to be relevant to this witness, you visualize it, which is like the meta chronology, but then you tell a story with it. This is where the lawyers do the magic. And frankly, we shouldn't spend time doing the top part. This is a bunch of waste of time. The more time you spend saying, where's that document? Fundamentally, as a law firm, every time somebody says, where's that document? Or I'm looking for something, it basically is telling me if I spend 30% of my time looking for a document, my systems are broken and I'm wasting time I should be doing storytelling. We're trying to get that number down as small as possible, but we still have that problem. It's just part of it. So we took this and basically said, we should do the I don't know as a strategy. So we know he's going to say, I don't know as much as possible. And when that happens, we set it up. So we asked him about the rules and procedures. He didn't know. And then we found a prior event from 7 years earlier that was very similar. And then there was a press release by the defendant that said they were doing new policies and procedures to make sure that didn't happen again. And so when he said, I don't know, we said, oh, were you ever trained on that? I don't know. Do you have any documentation of you being trained on that? I don't know. Did it ask you to look for it in this depo notice? I don't know. Let me show it to you. Does this, you see here where it says any policies and procedures and any training that you ever got on this specific issue? Yeah. Did you produce any? No. So based off everything you did to get ready for this deposition today, you don't have any knowledge of being trained on this specific issue. Yeah, that's right. I don't have any. And all of a sudden, the whole concept of the person saying, I don't know, as many times as possible. I then asked the follow-up question, trying to get a line on punitive damages of a manager in the company specifically stated on this date that there's going to be a policy and procedure to make sure that every employee always did this. And you don't have any information about that, do you? And the guy's like, no. The lawyer on the other side interrupted and started asking the court reporter to read back the last 5 questions because she realized what a disaster just happened because this is their strategy. They do it the same team every time. And all of a sudden, again, if you gather enough facts early enough on and you aren't spending dumb time doing the medical chronologies yourself, you have more time to do things like this.
So Taylor, are you going through the depositions and summarizing those and asking questions about the deposition to grab to those parts too? Is that what you're using the AI for too?
And actually, one of the things that's so interesting is not only can you give deposition summaries, you can ask, especially with John, I know your thing specifically has this, you can say, what's the inconsistency here? So you can give it
Okay.
a policy and procedure and say, hey, if you think he's going to say, I don't know, as much as possible, where is it? Like the ability to think with an AI helping you do these strategies is very valuable. And the more time you spend having your firm understand these things, the more you can move the needle in a way. Like it, when I say this, it sounds obvious. But when I was prepping for this depot, the night before, I can remember being like, I don't know what I'm going to do tomorrow in the depot. And he says, I don't know. But then you get the policy and procedure, you find some of the press release, and you start working with the AI saying, if he says, I don't know, what's the discrepancy that's going to be? How can I build this out? So, more than anything, the more complex what you're trying to do, the more systems are needed. And as much as you can let AI help you, and you always want to double check it. You worry about all the different things. Anytime AI doesn't have the hallucination problem for reasons that John will explain, but the idea is you want to take as much off your plate as possible of the thinking that now there's tools that do it for you. Use the chainsaw. Why would you cut down the trees? It takes you way longer. It's just you're not spending the highest value time on the things you should be spending it on. So basically, what is a system? In law firms, I basically view systems as something that reduces the cognitive load. I'm going to go through a little bit of this because I'm a little behind. The guy give you an idea of the systems that we build as a trial firm. Everybody talks about like, well, how do you get cases set up for trial? I want to just kind of give you an understanding. This is one little section. And like, this is some of the stuff that I build before trial. This was literally some of the building that we had for the $63 million verdict. Each one of these is a sticky note of direct crosses, pieces of evidence, stories that they're going to tell, and specific ideas of what we're fundamentally going to try and do. And people see this and they go, oh my God, that's a lot of work. Like, yes, that's the reason that the systems are so strong is we've built all these trial systems, gather all that information together, and then figure out what's the best way to present it through what witness at the time of trial to get the biggest leverage to most likely win. So, you guys have all been here and sitting through it. So basically, what I get asked the most is, can you look at this TBI case? I look at a zillion cases a week. And what we're doing is we're basically just giving away how to get value out of your TBI case because we're in California. We get a number of cases recommended to us from other states, but most of the time they're not big enough to make the difference. If you bring in a trial firm, they take a percentage of the fee and I say, hey, I'm not going to add that much value. Like if it's under 5 million bucks or something, like I'm just going to help you go get it. Like you don't need me. Like you don't. So the idea that is behind this is there's in any case, I don't care how big it is, I don't care how big of a TBI case it is. Let's say it's somebody who's a full quadriplegic, right? And you think the life care plan is as big as it can possibly be. You add a couple of small tweaks to that, and the life care plan sometimes will add another $10 million to it. And you do it in a way where you have some lay witnesses and you get some additional evidence that makes even the defense experts have to admit it. We've been in trial before where the defense doesn't call their life care plan because our $20 million life care plan is unimpeachable. And you set it up by understanding early. In every single case, there's one fact that's holding it back. I want to go to one thing and then we'll come back to that. But I'll just talk about it. This is basically what I do internally looking at TBI cases and getting them ready for trial. And basically what I do when I look at other people's cases is it significant? Like would an average person at a table say that's a significant case? Is the loss of earning capacity good? Is ADLs is activities of daily living? IADLs is independent activities of daily living. Before and after witnesses. Basically, you give all these a score from 0 to 3. 0 means you didn't do it. 3 means it's incredibly strong. You kind of put all these together and you then put these together, which is any of these significantly decrease the value of your case. The reason they decrease the value of your case is no one wants to give money to a meth user. Like, why? If you ask for $10 million and the defense stand up and says he uses meth, like it doesn't matter what you do after that. It's hard to get $10 million. Like that's just it. And that's the concept behind some of those. Value multipliers, these basically are the way to add significant value to the two above it. These take away, these add significant value to one of these others. Focus groups, I won't talk about it, but we do a lot of those. Blue anchor is basically, it's something that is a story that's so strong you can't unhear it. Give you an example of a blue anchor. If I have a client, take this off so you can hear it. If I have a client and I basically say, hey, my client's got memory problems and they, they're having issues driving and they're having issues being alone, no one cares and they don't understand why that's significant. They just don't. Versus if I tell this story, yeah, the son, he's testifying, put the son on the stand. Hey, tell me about your mom. She's got some memory issues. Can you give me an example? And he goes, yeah, I went out to her car after she'd gone to get groceries and she left her keys in the car. And I'm like, Mom, you left your keys in the car again. Like, that's not great. He goes to get the keys out of the car and he reaches in and there's a sticky note on the steering wheel that says, remember to turn off the car. You hear that story and you don't think, oh, she's got memory problems. You think, oh, shit, she shouldn't be driving. And the son then says, oh, yeah, we never let her drive after that. She shouldn't be living alone. She needs somebody in the house to help her. She's going to burn the house down. Like you immediately are no longer talking about memory problems. You're talking about such a fundamental difference. And they're the same case. Like that's the real heart of this is they're the same case. The problem is we are a firm looking for those stories. That story took me 8 months to find. We were trying to find it and it took that long to find. And so that's why you want to leverage on the things you can leverage on so that you can focus on finding the stories that you hear it and you immediately think, oh, no wonder they settled for $10 million. Well, yeah. Yeah. But like to find that is really hard to do. So going back to these, that's what a blue anchor story is. That's basically a visual of a story that's so strong that you stand up in closing and you point to memory and go, remember the sticky note? And you don't have to say anything else. That's what a blue anchor story is. Story breakers. This is something else we do for trial. Again, easy to explain, hard to do. Talk about the meth guy. I settled a meth case. It's confidential, but it was a very significant settlement. He was riding a motorcycle, hit the side of a truck, and they found a baggie of meth in his pocket. Right? And you go, oh, he's never going to get any real significant money. And shortly before trial, you put on something. Or John, you had a question? Go ahead.
No, no. I was just gonna say I can't wait to hear this. Guy's got meth in his pocket.
Yeah,
I want to give him anything. Go ahead.
exactly. So we hire an expert that is going to be the medical trust administrator for the rest of his life. And any money that ever comes to him is going to go in an account that can only be used to pay things that this trust administrator pays for. And it's going to go straight to rent or straight to food or straight to his ex-wife with the kid. And all of a sudden you aren't worried it's going to go to meth. And all of a sudden your life care plan makes sense. And everyone goes, oh, problem solved. Give you another example. We had a client that worked at a prison and this did go to trial and settle in the middle of trial for what our demand was before we started, but whatever. The defense was all hot and bothered by the fact that they had this fact that basically said as a prison guard, he eventually got not fired, but, pushed out because he was providing contraband to prisoners. And you go, oh my God, it wrecks your case. Like, how do you possibly deal with that? Well, you sit down with your client, you spend a lot of time with them, and you basically tell what happened. Tell me the truth. Oh, yeah, the guard above me hated me because I always would give cigarettes to prisoners so that they'd tell me who was going to fight so I could stop the fight before it happened. You hear that story and all of a sudden you're like, oh, he's a good guy. Like, sounds good to me. Like, do you have anyone that can corroborate that story? Oh yeah, this guy, that guy. Done. But to find those, you got to leverage on the things you can leverage on. Yeah. So the other thing is, this is something I end up talking about a lot. When people have stages of where they're at and settling a case, and how you talk to the defense lawyer and the adjuster really makes a difference, or the mediator. When you send a demand, you basically says, hey, we can go to trial. That's what this sounds like if you're this ready. The next level is experts are hired is, oh, I've already hired my experts. The next one is, oh, we're ready to settle. We've done the work to go to trial. Is like, you're ready to settle the case. But if you really want power and you really want to have the defense lawyer be like, oh God, like we need to really pay them the trial value, is it sounds like this. Actually, one more slide. This is the pyramid of what kind of value you're going to get out of the case. But it sounds like this. I don't care if you settle. Like it tells them everything. Like I don't care if you settle, because if you say I don't care if you settle or not, the defense is just like, oh my God, they are ready. Like I did all the work. I don't care if you settle or not. Like I'm gonna put on the case, you're gonna pay my client. Like whatever. Like that. You do that, and all of a sudden they start paying the real value. So this is internally, this is just what I think about. I don't have anything other than I've done a lot of TBI cases and I've written a book on it and I've talked to a lot of lawyers. Like that's my frame. I talk to a lot of lawyers every week about their TBI cases across the country. This is how I think about it, is if the defense is offering 0 to 1, is you just don't have enough credibility. And that is covers a lot of things. The plaintiff doesn't have enough credibility, the witnesses aren't, the experts aren't, a lot of things there. A 1 to 3 is you have a TBI, but there isn't an anchor number that's significant that the defense believes. 3 to 10 is you do have a TBI and you've got an anchor of the, hey, they're making 150 grand a year and they were 30. All of a sudden, that's where that one's going to go. 10 million plus to get that kind of value is they have to be a proven trial firm. Like they have to have gone to trial enough that the defense is like, oh my God, if we don't pay them, they're going to go to trial. You have to have a really credible client that the defense is like, yeah, we like that guy. And the numbers have to be something the defense experts like, yeah, those numbers are legit. That's when you get that valuation. So what I kind of wanted to do today is, if you guys want my internal this, I'm happy to give it to you, because frankly, this is what you should be looking at for adding the most value you can get to your case. And we're debating if we give it away or keep it internally or what we're going to do. But the idea is, I kind of view it as we use this on our own cases to like audit, like, are they ready for trial? Like how ready are we? How much are we going to actually be able to get across the finish line? There's a couple other terms on here that come from just my specific stuff. I want to explain black swans. Black swans is you find a fact that's so devastating, the defense basically goes, oh my God, we got to settle the case. The PG&E one, when they said they didn't know about the training, that was a black swan. Another black swan, it comes from the idea of black swans over time. If you say, hey, what color are swans? Everyone's like, white. Well, you can say that until you see a black swan, and then you know they're not always white. But until you see the black swan, you think all swans are white. Like that's the concept. And so like when you have a case, like we had a case years ago where a bus driver, there's no kids in the bus, but a bus driver was driving down the road and machine farm equipment was coming the other way, and the arm swung out and hit the bus driver, basically across the lane, and she hit it and got a TBI and injured and all that stuff. And the mediation, they were under 7 figures and they were slightly over it. And then we basically are like, oh, walk in the room, tell them this person's name, and tell them that person basically said, oh yeah, I told the boss that he should have strapped the arm down and it was broken, it was going to cause a problem, and the boss said, we're late, let's send out the truck anyway. Black swan. Like, oh, the value is so huge after that, they have to settle that case, so they risk like a jury just throwing the book at them. So basically, every case has one fact more than anything else that's holding the case back from the highest valuation it can get. For example, the TBI case, the Glasgow Coma Scale guy at the scene, that was the fact, is they didn't believe it was a TBI. We found that fact, blew up the case. The meth fact, you got the guy that's got meth, and they're like, we're not going to give the guy money until you tell the defense, hey, we got an expert that's going to do this for him. And all of a sudden they're like, oh, we do need to pay more money on this. It's, you figure out where the one thing is that's going to change the value of the case, and then you just break it. Breaking it's the hard part. Talking about it's easy, but you do it enough over and over again, leveraging the AI tools and other things so your time is more efficient. This is what you get. So, yeah. This, if you want the checklist, ernst.lawgroup.com/webinar materials. And I think, John, are you going to give them PowerPoint?
Yeah, no, I appreciate it. I know all this is coming out in your book, but I was going to ask you if I could grab hold of this and send it out to the people that are on this webinar.
Sure. If you want to do it, email them.
And on there, I'll go ahead and put your contact information if it's okay with you. So if they have a question on the BI case,
sure.
Your phone might blow up a little bit.
It's okay. The goal is, yeah, the phone, that happens, but at the same time, like that's what we should be doing. Like the lawyers want to all right, I'm gonna get on my soapbox for a second, but a lot of the trial firms get bigger the more cases that get referred to them. Our goal isn't to do that, and because we aren't planning on getting significantly bigger, when a case doesn't meet the threshold of like, hey, we're going to really come in and do something or try and add significant value to this, we just give away, hey, here's what I do, which is been an interesting thing because I don't care. It's the reason I can write the book and say, like, this is how you do it. Like, I give away the secrets. This is from A to Z how we plan on trying to figure out what the symptoms are, which I didn't talk about this in this lecture, but the idea is you figure out what the symptoms are. Yeah. Man, I could talk about all this all day, but the idea is when you see in medical records where it says, like, using your AI tools, hey, broken ribs, all that really is documenting a story that you haven't found yet. Because if he's got broken ribs in the ER, he's got a story about it's hard to breathe, or when he's at home, he's trying to eat something and he can't, or he's got a broken wrist and it says broken wrist or fractured ankle or whatever the injury is. It's a sign that there's a really good story out there that you don't know. And especially when it comes to TBI, because TBI involves so many different aspects of every part of your life that there's a zillion stories. And that's why the cases are so complicated, is every TBI is a little bit different. And you got to spend a ton of time with the client. The number of calls I get that, oh, I've got a really good TBI case. And then they say the following, except the client is so difficult, is so high. And my question back to them is, if they've got a brain injury, what do you expect? That's the reason the cases were so much, is they're a difficult client. Yeah, you spend way more time talking to them and they do things. You're like, why did you do that? You set meetings and they don't attend and they don't listen to you and prepping for depo. All right, you want a pro tip? Prepping your brain injury clients for depo. You do not want to do one depo prep session. That is not the right way because generally they have a memory impairment. Not always, but most of the time. If they've got memory impairment, why are you making them sit for an hour, hour and a half with you to educate them on how to do a depo? They're not going to remember. You need to do 5 meetings that are 5 minutes long or 10 that are 10 minutes long. And you prep them over and over and over and over and over again. And then don't be surprised at depo when they don't remember. And you aren't trying to change what they're saying. You're just trying to get them to not misrepresent something because they got a brain injury. The number of times I have a brain injured client that says something that I know is fundamentally, demonstrably false in the medical records, I don't know, 30%. Like they do it all the time. And then then you got to, and then you're like, oh man, I know that, he knows that's not the truth, but they don't remember. So you got to prep them in a different way. Like the whole approach of how you do the TBI cases is different. And it's something, again, I talk about a lot. Like everyone's like, oh, I don't do medical malpractice, but I do these TBI cases. I'm like, oh, I think I've done a medical malpractice case. I've done TBI cases. I think TBI cases are harder. But like everyone lumps them in with personal injury, other stuff, because they're like, oh, they're just the same as any other case because you look at the medical records. I'm like, no, you're leaving money on the table when you do that. Don't do that. And I know that because I used to do that. I used to look at the diagnosis and be like, oh, it says skull fracture. What's a skull fracture worth? I'm like, I'll look back at my younger self and be like, no, don't do that. Find out what his symptoms are. What's the most significant interruption to his daily life? Find a lot of stories about that. Get them to your expert. Have other people talk about your guy. So
Yeah, so it just, the big message that I'm getting from you is, automate as much of the grunt work as you can so that
yeah,
you can spend your time tracking down witnesses, tracking down friends, tracking down family members, talk to all of them so you can get the story you need in order to make it worth a significant case.
the biggest constraint to TBI cases is the work as being done on things that have been solved for. Like that's not where you want to be spending your time. You want to be spending your time on the area that's going to move the needle because the amount of work, if you go to trial, you realize how much of what actually ends up in the courtroom has nothing to do with how you work up the case beforehand. Like most of what you're doing in discovery and in depositions is not a significant factor to whether or not you win big at trial or not. It's just not. And I know that sounds insane to say, but like it's the credibility of the plaintiff, how well you prep the plaintiff, and how well you figure out where the significant problem is in their life. And that's what you fashion the case around.
So question for you.
Yeah.
You end up dealing with a lot of experts.
Yes.
You deal with the same experts on the other side on a regular
Yes.
basis? Are
Actually,
you
great question. And you should, if this is where you're thinking about going, you got to figure out how to get the previous depots so you can put them in some AI tools and find out where their discrepancies are. Because the number of times I end up in trial and I know I've got 10 depositions of the expert beforehand and they saw something that I know is verifiably false and I can prove it, but you can't, it's, you got to be using the tools to do that.
Yeah, so are
Like
you putting them in a folder in the knowledge base that we have so you can hold on to them so everybody in the firm can grab them when they need them type of thing?
the more you give the AI tools to leverage off of, the better results you're going to get.
Yeah.
Everything should go in the knowledge base to be able to figure out what, because like if you are working on your own and you are just trying to do it on your own, like your co-counsel can't see it, the other lawyer working on it, your paralegal can't see it. You need it all centralized in a place. Again, the data, like once it's segmented and understand where it is, like you need to keep it where everybody has access.
By the way, you asked about some of the things that we've done. One of the new things that we've done is that you can share a case with a co-counsel right
Oh,
through
that's great.
the tool.
Oh,
So you could
that
send
would,
the whole case with everything that you've done, all the medical records, all the questions about
oh my gosh.
inconsistencies and depots, everything.
That solves such a big problem for us because the number of times somebody's like, I want to tell you about the case, and they send me 2 medical records, and I'm like, where's it? Where's the plaintiff depot? Where's the discover? Where's this? Where? And they're like, oh, my office will send those to you. And then they'll send 5 emails with 5 different sets of stuff. And I'm just like, you just gave me a ton more work to try and figure out how to help you. And I'm not even taking this case. Like,
Yeah.
get it all in one spot and send it so that I can look at it and have an understanding of like what's actually going on and say, hey, here's the big problem with the case. You got a life care plan that's going to be 5 million, you need it to be 10. This is the problem, this is where the fight's going to be. But until you get all the context, you can't do it. That's fabulous that you guys are doing that. That's really helpful because that's the bane of trying to give people advice about their TBI cases. It's a problem for us a lot of the time.
Cool. Well,
This was great. I appreciate the being able to hang out with you some and talk about. I know I was on my soapbox there a little bit, but I feel strongly about this if you guys can't tell.
yeah, just a little bit, but that's cool. And I appreciate you coming on and sharing some of the stories and what can help these folks, really dig into these TBI cases and what's going to make a difference. Because like you said, a lot of attorneys won't share that information freely, right? And
Nope.
and I appreciate you letting me share some of the information that you shared in this with the folks that are on this
Yeah,
call.
absolutely. If they want the slides, the thing that I think is the most valuable is the
That checklist.
trial readiness thing. Yeah, the checklist, which you can get it from us. You can get it from John. The way you go get it is the ernst-law-group.com/webinar-materials, and it'll just email it to you. I think this guy. If we can put that in, I can put it in chat or whatever, and I'll just email you directly. We don't spam. We don't have any marketing, whatever. I'm not going to send you a bunch of other shit. I don't care. This is just, I'm trying to figure out like how do I get it to you guys. And the problem was, I can't, the tech guy was telling me they got to go download it or something. I don't know.
Yeah, I can go ahead and share that with everybody. So
Great.
it is 1 o'clock. So I want to thank everybody for joining today. I want to thank Taylor for hopping on and doing this with us. Really appreciate you, man. And
No, this was great. I look forward to hanging out at the next conference where we see each other. We'll
sounds good.
get
Me
some food
too.
or something.
All
Yep.
right.
Hey, thanks
Thank you,
everybody.
everybody. I hope you have a great rest of your day.
See you. Bye.
Bye.